Good morning. Today is July 24th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler, David Schraga, and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great presentations. Rather, we ask people to contribute to a food bank if they like what they see. And our audiences have been so generous in donating in honor of our great speakers every week since the series began. One of my favorite parts of the program each week is when we announce the running total of just how much our audiences have contributed. Jean and David, would you please do the honors?
Hi, yeah, with pleasure. You guys were up to $844,873.24. So kudos to everyone who's donated, who keeps attending. This is 5 years in here. And we are aiming to hit $1 million before the end of the year. So I like to say, feed your mind while feeding the world. And that is definitely what this greater global legal community has done and is doing. And thank you all so much. We're looking good. Thank you so much. Please let us know what you donate, and then we'll be happy to add it to your running total.
Thank you, Jean. We have another wonderful presentation today. David Hoffman, a leading mediator in the country and a personal friend, I'm delighted to say, will be talking today about the art of impasse breaking in mediation. Mediators use a wide variety of tools to break impasses in mediation, and David is the master of those. We use everything from reality testing and risk analysis to range bargaining and double-blind mediators' proposals. David is not only a longtime mediator, but he also teaches mediation to law students, and he trains mediators for the program on negotiation at Harvard Law School. David has collected a toolbox full of techniques which he will share in this presentation. In addition, David's thoughts and ideas on impasse breaking will be published by the American Bar Association later this year in a book with the same title as today's presentation. David is, of course, the John H. Watson Jr. Lecturer on Law at Harvard Law School, where he teaches courses on mediation, diversity and dispute resolution, and legal profession, collaborative law. David is also an attorney, mediator, arbitrator, and founding member of the Boston Law Collaborative, LLC, where he handles cases involving family, business, employment, and other disputes. He's mediated or arbitrated approximately 2,000 cases since 1991, and he's still going strong. Before he founded the Boston Law Collaborative in 2003, David was a litigation partner at the Boston firm of Hill and Barlow, where he practiced for 17 years. He's a past chair of the ABA section of dispute resolution, a distinguished fellow of the International Academy of Mediators. He has received the Lifetime Achievement Award from the American College of Civil Trial Mediators and from the Academy of Professional Family Mediators. He's published many books and articles. He earned his bachelor's degree from Princeton, a master's degree in American Studies from Cornell, and his law degree from Harvard, where he was an editor of the Harvard Law Review and research assistant for Professor Lawrence Tribe. David, we could go on and on with your credentials for a long time, but you're here to educate us, my friend. So please give us a few words about the food bank to which you would like people to contribute if they're in a position to do so, and then on with the presentation. David Hoffman, the floor is yours.
Thank you, Jeff. Very kind introduction. And boy, Jeff and I go back a long ways in the ABA section of dispute resolution. And Jeff, I think you and I even played like a tune together once for to entertain our members of the section.
Yes, we did. We did a little riff on Simon and Garfunkel. We wore our black turtlenecks. You played guitar, and we talked about 50 ways to leave your lawsuit.
Right. Yeah, you have a sharper memory than I do. I didn't remember all that detail, but it's really good to be here. I'm really honored to be part of this program, which has brought so many wonderful people into these weekly events and raised so much money for such an important cause. More important today than ever. I think we might agree. Greater Boston Food Bank is near and dear to my heart, and you'll see the link. I think there's a link in the chat. Thank you, Natalie, for putting it there, and it's on the slide. This photograph is the building in South Boston where Greater Boston Food Bank collects food from corporate donations and purchases that they make. And here's various law firms and businesses and community groups come in and volunteer. My little tiny little boutique firm, Boston Law Collaborative, we've gone in to volunteer to help sort food. Another way people support Greater Boston Food Bank is fundraising events. This is a picture of the Boston Marathon team. I'm in the front row of this picture. Back when my knees were better, I was running with this team. I was probably the slowest runner on the team, but we raised significant money for Greater Boston Food Bank as charity runners in the Boston Marathon. This is a picture of the Boston Law Collaborative contingent at Project Bread's Walk for Hunger some years ago. I'm on the right in that picture. Right next to me is my daughter, Lily, who I think was none too happy about being recruited into a 20-mile charity walk, but she did it to her credit, and we raised money for to stem hunger in the Boston area. And of course, if you want to just write a check or click on the link and donate directly, that's all extremely needed and welcome. And you'll be joining, if you contribute to the Greater Boston Food Bank, a campaign that last year distributed more than 107 million pounds of food, providing nearly 90 million meals just in 1 year. So it's a huge and impactful operation, and I appreciate the donations that anyone might make. Now, on a lighter note, those of you who know me know that I like to start workshops with New Yorker cartoons. So I've got 3 here, and I think I might have 1 or 2 later in this workshop. This one, I don't know if you can see the caption. It says, "So does anyone else feel that their needs aren't being met?" And that's me with a spear, and that's Jeff and Natalie out on the precipice. So just speak up. But this is the opposite of what we want. Please put questions and comments in the chat, and hopefully there'll be time at the end for some Q&A and discussion. Never think outside the box. Well, we're going to think outside the box today, and it's one of our superpowers as mediators. Not only thinking outside the box of substance, but process as well. And this Buddhist concept of beginner's mind is illustrated in this cartoon, where you see one monk sort of in an un-Buddhist-like way bragging that his mind feels especially empty today. Well, the concept of beginner's mind is that we are inviting the judgy parts of our minds to take a step back, create some space for some ideas that perhaps we hadn't considered before. Now, Jeff kindly mentioned this book that's coming out in the fall, the American Bar Association. This cover, apropos the John Landy talk that was a couple weeks ago. I asked ChatGPT to look at the table of contents of my book and create a cover, and this is what ChatGPT came up with. I'm sure the ABA will come up with something better, but this is the tentative cover, and so hopefully in the fall you'll see it online, and if it looks interesting, I encourage you to check it out. Agenda. I want to talk about process interventions, substantive interventions. And if there's time at the end, I'll talk about an impasse prevention technique that I find particularly valuable, which is the internal family systems model. For the talk that I'm about to start, I want to share the premise of the talk, the idea of impasse. And that is that you're in a mediation, you've already done all the basics. You've heard the parties' accounts of what happened. You've explored their feelings about what happened. You've elicited their underlying interests. You've brainstormed options, and you've considered the alternative to a negotiated agreement. Some people call it BATNA, best alternative. Some people call it MALATNA, the most likely alternative, for example, litigation. So all that has occurred. What now? The parties are really stuck. So in my view, the very first thing to do is to diagnose the settlement barriers. What are the problems? Sometimes the problem is missing information. So for example, yesterday I was in session 2 of a family business mediation. Married couple, they're getting a divorce. They're trying to decide what to do with a business that they created together that's very successful. Is there going to be a buyout? Are they going to sell the business? Are they going to continue to co-own it? Those are 3 of the options. There are other options, but they're having trouble figuring out the value because there's some missing information about major tax credits that they're entitled to for 2024. So they need to get their accountant on board to fill in that blank in the puzzle before they can sort of figure out what their options are. Sometimes they're missing people. So, for example, in the same case, both husband and wife agreed that there is one critical management employee who really knows what's going on in the business. It's in some ways even better than they do, because sometimes the staff doesn't want to talk to the owners, but they'll talk to this key manager. So they asked me if I'd be willing to meet with her separately. And I said, well, how about if she meets with us all together? They said, oh, no. She'll be much more candid if she meets just with you. So I said, okay. I've had other cases where some person that you wouldn't expect, for example, in a case of marital mediation, people wanted to stay together. They said the critical person is the husband's mother-in-law, and he needs to get on the same page with her. We went to a bagel shop and settled the case, and the couple is still married. So whether it's business, family, or family business, sometimes there are missing people. Sometimes you have to change the players. Now, I had an employment mediation not too long ago that involved some very complicated employee stock ownership plan issues, ERISA issues, and the senior lawyers in this case couldn't stand each other. They literally could not be in the same room together. They were so disparaging of each other. I tried to help them to dial it back. I was unsuccessful. However, they each had an expert, and the experts knew each other, respected each other, liked each other, and they actually negotiated the final dollar numbers that needed to be negotiated to bridge the gap. And then the junior lawyers, who actually got along pretty well, went in a room with me, and they typed up the agreement. So figuring out who are the people who can have the best conversation. Now, I want to put in a plug here for a very special member of the Boston Law Collaborative team. And I sometimes bring her into my mediations. And this is my golden retriever, Bella, whom we rescued from a shelter in Serbia. She has her own page on the Boston Law Collaborative website. You can click on links at the bottom of the page with articles about dog-assisted mediation, dogs as conflict mediators, and see-spot mediate. There are a lot of people. I got this idea from Jim Malamed, who told me about how his golden retriever helped him settle cases on a regular basis. And Bella, by the way, is always willing to work pro bono. So we have fun bringing her into our cases. And even if the parties can't stand each other, they all love Bella. Golden retrievers are just, that's their superpower, is being relational. Okay, back to our list of impasse breaking tools. Partial agreements. So again, just yesterday, I'm meeting with this family in this family business case. There are certain interim agreements that we were able to reach. We typed them up, we put them on the Zoom screen. Most of my work these days is Zoom. Um, Email it, they send it to their lawyers, and we have momentum. Momentum is super important in breaking through impasses. Other ADR processes, sometimes we have to be good triage resources for the parties and help them understand that maybe a part of the case could be sent off to arbitration. Maybe a part of the case needs to go to some kind of case evaluation. Maybe part of the case actually needs to be litigated because they actually need a precedent on something, but they don't need to send the whole case to litigation. So being a process expert is one of our superpowers. Narrative. So I've had a number of cases where the parties are stuck, and I find that it's really helpful to go back to the well and hear their stories. And in fact, I'll just mention one thing that I do differently now than I used to do when I started mediating. Typically nowadays, we don't use joint session that much in business and employment cases. A lot of lawyers especially feel like there's more risk of throwing gasoline on the fire. And so we go very quickly into caucus and just have a procedural joint session. But what I tell the lawyers and the parties before we even get started is that the first caucus, I'm not going to get to the numbers by design. In the second round of caucuses, we'll get to the numbers. But in the first round, I want to hear their story. I want to hear what happened. What was the impact for them? And sometimes if we're at an impasse, I go back to hear more about their journey. And sometimes I've found that they tell me stories that are so deeply meaningful, and I can sometimes get them to meet together and share those stories because you can disagree with a position. You can disagree with a legal theory or an argument, but you can't disagree with a narrative. It is what it is. And sometimes narratives have a way of opening up people's hearts and helping them demonstrate some vulnerability that breaks through the logjam. Reminding people about common interests. We all know that move, right? Reduce the transaction costs, for example, reduce publicity risk, the imposition on their time. Sometimes people need to be reminded of that and also reminded of the opportunity for trades. People have differing interests. So somebody is concerned about the time value of money, and they're willing to make a payment plan over time. Some on the other side, they don't mind if the payment is made over time. They just want to make sure there's security. So there may be differing concerns. That's not a problem. That's actually, it's not a bug, it's a feature. Metaphor is one of my favorites. So I think we mediators frequently use metaphor. This little photograph illustrates one that I use a lot, which is the rear view mirror and the windshield, reminding people that our goal is to, move forward. Now, in a car, you wouldn't want to drive a car that didn't have a rear view mirror. But if the rear view mirror was as big as the windshield, we never get anywhere. So of course we're going to pay attention to the past, but our main focus is the future. That's all we have to agree on. We don't have to agree on what we're seeing in the rear view mirror. Jose Ortega y Gasset said, the metaphor is the most powerful tool known to humankind. And I sometimes use the whitewater rafting metaphor. Yes, sometimes mediation gets choppy, but if everyone stays in the boat and they don't hit each other with the paddles, we'll hit some calmer water and we'll get to our destination. Or in family cases where there are kids, I got this metaphor from my colleague and friend Richard Wallman, the idea of parents as co-pilots. You got to shut the door to the cockpit so the kids, who are the passengers, are not listening in on your conversation, because if you disagree, it's very unsettling. And you have to agree on the destination. Number 10, food. I have found so many times that people eating together will kind of let their guard down a little bit and talk about, their food preferences, talk about amazing meals they've had in the past. And in one case, mediation that went 3 days, the parties took turns. There was a huge group on each side. They took turns arranging for lunch. And they paid very careful attention to the food preferences of the people on the other side, the vegans and the gluten-free and the vegetarians, etc. And it was a way of demonstrating caring and connection. And it really helped us get through the case. Silence. Sometimes people will say something that is so profound, that's so moving. We just say, wow, and just live with the silence for a moment. Mahatma Gandhi said, speak only when it improves upon the silence. Sometimes taking a break. People sometimes need distraction. And Eric Galton tells a great story about going for a walk around the lake in Austin, Texas, with the CEO, who was one of the parties in the case, with everyone's permission. And after coming back from that walk, things started moving. So sometimes we have to be thoughtful about breaks, and also recognize that sometimes taking a break you can lose momentum. So there's a lot of intuition. It's more art than science. Role reversal is building on something that we do all the time. We say, I think what I'm hearing you say is X. Am I getting that right? Then cross-looping, we ask the parties to do that with each other, to say to the other party, what I'm hearing you say is X. Am I getting that right? And if they're not, find out what they missed, and correct it. Role reversal is really kind of the next step, and kind of a risky step, is to ask each person to state what's going on, what their concerns are, as if they were the other person. I don't do this very often, but when I've done it, it's been very powerful. We all know the power of apology. Question is, sometimes there's a need for mutual apology. And how do we tee up apologies? So one technique that I've found useful is to meet in caucus session with folks and ask them, is there something if you could roll back the videotape, is there something you would do differently if you could? And I would say that 9 times out of 10, the parties can think of something they would do differently. And then I asked, do you think the other side knows that? And usually the answer is no. Would you be willing to say that in a joint session? Okay. And if you get that from both sides, it's really amazing to me. The idea I would have done this differently often leads to an apology. Now, we have to be careful about the power dynamics here, because many of our cases involve, folks who are in a greater position of power. And we don't want the person who is in a lesser position of power to feel that they are creating some vulnerability for themselves. It's really uncomfortable and may change the dynamic in an unhealthy way. Acknowledgement. I think we mediators can be cheerleaders, if you will, for the progress people are making. And really, even if they're kind of stuck, we can appreciate their candor, their focus, their willingness to try to work through a difficult situation. Case evaluation. Now, I don't know about other mediators in this Zoom room, if you're finding this, but I'm finding that people are asking me less frequently than they once did to do case evaluation. And I have some theories about why that might be the case, but I'm still asked to do it. And when I am asked, I usually use a decision tree software tool. This one's created by a company called treeage.com, or it's TREEAGE, triage, treeage. And it's a very good software tool. I also invite the parties to do their own case evaluation and see what kinds of assumptions they make about the uncertainty nodes in the decision tree, and what kinds of end node values that they put on the case evaluation. Sometimes we do case evaluation without this, mathematical modeling of the risks and opportunities. I also generally, when people ask me to do case evaluation, I generally recommend that they have someone other than me do it, usually a retired judge. In some complex cases, we've even had 3 case evaluation opinions from retired judges, non-binding, of course, and that avoids the risk of an aberrant decision. The use of hypothetical proposals. I find this particularly helpful in business and employment cases, but sometimes in family and family business cases too, where you're in caucus, you're in shuttle diplomacy mode, and you go to one side, you've got a sense of what each side might be willing to do, and you go to the other side not with a specific proposal, but asking if the other side was willing to do X, is that something that you too could consider? And then they say no, but we could do Y. Okay, well, now you've got some valuable data. This is very closely related to the next topic, which I'm going to dive into in greater, actually a couple notches from here, the mediator's proposal. But let me talk before that about the confidential last best offer. This one I learned from Judge Toro, the late Judge Toro, U.S. District Court judge in Massachusetts. He used to call the lawyers in and ask them to write on a piece of paper, secretly, privately, their last best number, what he used to call their no BS number. They'd fold it up, they'd hand it to the judge, he'd look at the 2 pieces of paper, and he'd tell them, okay, we're going to set a trial date, or you should go out in the hall because I think you can settle this. Very valuable technique. And what I've found as a mediator is when the parties do this, after I say to them, I think we should keep talking, one of them will often say to the other, I'll show you mine if you show me yours. And that gets a laugh. But then they do it. And now the bookends have moved much closer, and it really tees up a settlement. So mediator's proposal. I want to spend some time talking about this because it's one of the most used tools, not only in my mediation toolbox, but I would say many mediators, particularly business and employment mediators. Let's talk about what we mean by mediator's proposal. So it's a prediction of what the parties might be willing to do. It's not case evaluation, which is a prediction of what the court will do. And the slides that I'm about to show you, I actually show these to the parties in some cases to understand not only what a mediator's proposal is, but what the ground rules are and what I'm going to be doing when I come up with my proposal. How do you arrive at the proposal? So the ground rules are that all parties must want the proposal. The mediator talks with the parties about what terms should be included in the proposal. I've found more and more over the years how important this is to get the ancillary issues nailed down about tax treatment, confidentiality, things of that kind, so that we don't wind up, we've got a number, but now we still have an impasse. The mediator makes the same proposal in separate caucus rooms and asks the parties not to respond right away to the proposal. I want to not know their response so that I can go into the other room not knowing. And I also want them to have time to talk among themselves without me present, unless they want me to be there. And if they do, I'm happy to be there. The mediator gives the parties time to think about it. Then I return to each caucus room, and of course you can do this in Zoom as well as in-person mediations, to find out whether the response is yes or no. Then I report the responses to everybody, and it might be more than a 2-party case, so there might be multiple parties. I report the responses only if there are 2 yeses or 3 yeses, however many parties there are. So what that means is that each party can take the risk of saying yes, and the other side won't know they said yes unless they too said yes. So this is what Jeff was referring to a moment ago. He introduced me about double blind. So let's take a sample case. The plaintiff demands $6.5 million. The defendant offers $250,000. This is at the beginning of the mediation. By 6 p.m., the parties are stuck at $2 million and $1 million. They want a mediator's proposal. So I explained to them what I'm going to do. I know for certain that there's a 100% chance that the plaintiff would accept $2 million. And I know that there's a 0% chance that the plaintiff would accept 1 million. I know that there's a 100% chance the defendant would pay $1 million and a 0% chance they would pay $2 million. So the question in my mind is, where's the crossover point? Where is the number which, if you move the number north or you move it south, you reduce the overall chance of there being a settlement? So that crossover point might be over here, it might be over here. There may be no crossover point. There might be no zone of possible agreement. But my job is to try to discern from talking with the parties, my intuition, where their resistance point is. And there's a lot of data, some of you may be familiar with this data, that shows that plaintiffs typically move $2 for every dollar that a defendant moves. Now, this tends to be more the case at the beginning of the negotiation and less the case toward the end. But in any event, I use my judgment, my intuition, make my proposal. And then sometimes I have one yes and one no. And then sometimes the party that said yes discloses to the other side that they said yes. And then we can negotiate between the yes number and where the no side is. Okay, back to just a few more. Reminding the parties that mediation is voluntary. This is what we call a paradoxical intervention, because we're not really wanting to show them the door, but we want to see what's their motivation for staying. Okay, now here's the second topic that I'm going to dive into in some depth, because I'm finding this more and more useful with each passing year, range bargaining or bracketed bargaining. So we're trying to figure out where the ZOPA is, we know what the defendants, we think we know what the defendant's range is. We think we know what the claimant's range is. We believe there's a ZOPA, but how do we get there? So here's a case, and these are actual numbers from an employment discrimination case, obviously leaving out names and identifying information. And in this particular case, even before mediation began, the company had made a severance offer of $18,000, in response to which the plaintiff demanded $230,000. Then the plaintiff hired a lawyer, and the demand went up. Well, that usually makes it hard to get people to mediate, but they did. The mediation began, and the bookends were $307,000 for the plaintiff, $18,000 for the defendant, and the ball was in the defendant's court. The defendant offered $30,000, which, from their standpoint, felt like a healthy move, but from the plaintiff's standpoint, felt like bupkis, which is a technical negotiating term meaning not very much. So the plaintiff came back. They reduced their demand by $17,000, which was more than the numerical move of the defendant, they pointed out. But from the defendant's standpoint, that was not a very good move. So the defendant said, let's try some range bargaining. So the initiative to do range bargaining can come from the mediator, can come from the parties. And they said they would be willing to move their $30,000 to $50,000 if the plaintiff came down to $110,000. So the plaintiff said, no, we're not going to do that, but we'll come down to $190,000 if you come up to $60,000. The defendant thought that was healthy move. They said, we'll come up to $60,000 if you come down to $120,000. They said, no, we'll come down to $150,000 if you come up to $70,000. Now you can see the bookends are getting closer and closer. The defendant says, no, we're not going to accept that range, but we'll do something even better in a way. We'll come up to 80. They jumped over the 70, so we'll come to 80 if you come down to 100. Plaintiff said, no, we're not coming down to 100, but we'll come down to 120 if you come up to 90. Then the defendant said, our bracket is 85 to 95. And at that point, the plaintiff said, no, we're not going to respond to that. And the plaintiff requested a mediator's proposal. So you can see these impasse breaking techniques can be combined. And the defendant said, okay. So I made a mediator's proposal, again, using my intuition, my judgment about where I thought the parties were going to move. 93,000 plus the defendant would pay the mediation fee, the plaintiff's part of the mediation fee, which at that point was about $4,000. So it was about 8,000 altogether. The plaintiff's portion was 4,000, and the plaintiff rejected that, and defendant accepted. So that was secret, right? So then I said, well, why don't we go back to bilateral bargaining? And it was plaintiff's turn. Defendant had made the last offer, and they said 99,000 plus the mediation fee. So essentially 103,000. And the defendant said, no, we're not willing to do that, but 99,000, 95 plus the mediation fee, and that was accepted. Now, I'm going to show you some colors. Added some color to this chart because I want you to focus on the blue, which represents the numbers coming down from the plaintiff's side, and the green, the yellow, which is the defendant coming up. So you can see that the gap here was 85 and 105. But in some ways, I'm sorry, it was 120 and 85. But in some ways, the most relevant gap is the midpoint. Both sides were paying a lot of attention to the midpoint of these ranges. And the fact that it was 90 and 105 gave them hope that we're actually getting somewhere and we can get this done. Contingencies. We're in the home stretch here. Contingencies. There are all kinds of contingencies. For example, in corporate transactions, there could be an earn-out. The parties might disagree as to what the value of a company is, but if the seller is going to get a piece of the action, then they share an interest in the success of the business with the buyer. In employment cases, sometimes there's a clawback of funds if the employee gets another job. Indemnification is sometimes important in corporate transactions, figuring out how to share the taxes if there's a liability that arises from the settlement. Sometimes if it's a business or real estate, there needs to be some kind of inspection, financing contingencies, appraisal. We're going to get into appraisal in just a minute, because I have a methodology I want to share that I've found really useful. A right of first refusal. If you're selling a piece of real estate, selling a business, you might want to have the right to buy it back. Profit sharing arrangements. These are all ways that we can help people be creative, prime the pump of option generation, where there's uncertainty about the future. That's what contingencies are all about. And creating two different or more than the plan A, B, C, D. This one I'm very fond of, dual or multiple offers. So one party's about to make a proposal that I think is not going to be well received. It's going to be viewed as kind of extreme. So I say to that party, I think you might get pushback on this, but here's an idea that you might want to consider. Why don't you make this proposal that you want to make and say, in the alternative, we would be willing to submit the case to non-binding case evaluation because we really think that we're right and we have the courage of our convictions and we're willing to share the cost of case evaluation. And I've found that sometimes that makes an offer which might otherwise have been viewed as extreme more acceptable because the other side doesn't want to do the case evaluation. Or maybe they do, and maybe that turns out to be a good impasse-breaking technique. There are other ways to do these kinds of multiple or dual offers. Auctions. Sometimes you have real estate or a business or other property, and both sides want it. So how do we resolve it? Well, an auction is a pretty standard way to do that. Well, how do we structure the auction? So let me just share three different ways that I've found useful. One is the internal auction. The only bidders are the parties. And we structure it by saying the offers have to be made within a certain interval of time. Could be within 5 minutes or within 24 hours, depending on how complicated or big an auction it is. And we also have to agree on the intervals of bidding. In other words, the increments have to be at least $50,000 or $100,000 or some number that is meaningful rather than, a dollar. Another kind of auction involves exposing the whatever's being sold to the market. So the parties can bid, but so can the public. And what that does is it tends to favor whoever winds up to be the seller, because by exposing this business or real estate to the public market, you're bringing in other potential buyers, drives up the price. Sometimes people don't want that kind of exposure. They may not want the publicity associated with an external auction, but sometimes they want to make sure they're getting fair market value if they're the seller, and they want an auction that's exposed to the public. The third auction methodology I want to share is really clever. I learned this from a couple of economists who wrote this up in a book. It's called the adjusted winner auction. And the way it works is if you have multiple items, for example, a divorce mediation, the parties list the items, and each one on a private sheet writes down what they'd be willing to pay for that item. So let's say it's the grand piano, and one party puts down $5,000, and the other party puts down $2,000. The piano goes to the higher bidder, the one who bid $5,000, at a price that's the average of the two numbers, which is $3,500. So the buyer feels like they got a bargain. Hey, I thought the piano was worth $5,000. I got it for $3,500. The seller who didn't want the piano says, hey, I got a premium. I got $3,500 for a piano that I was only willing to pay $2,000 for. Okay, now I mentioned appraisals. So joint experts, joint appraisals. There's a methodology that I've been using more and more over the years where it's a three-step process. And the way it works is this. The parties jointly hire an appraiser or a business expert for a non-binding opinion. And then after they get that opinion, they negotiate. In round two, if they don't agree, they jointly hire, and joint is important. They don't communicate ex parte with these appraisers. They jointly hire a second appraiser for a non-binding opinion, and then they negotiate. If they don't reach agreement, they go to the third joint appraiser, and then the average of those three appraisals is binding. We also have an arrangement that if any one of the three appraisals is more than 15% different from the average of the other two, it's rejected as an outlier. That way we avoid the risk of an aberrant opinion affecting the outcome. I have found that in the vast majority of cases, people never get to round three because they're actually uncomfortable with the idea of being bound by the appraisal, and they negotiate, and they also want to avoid the cost and delay of the three appraisals. Now, I want to talk about a couple of problems, and then I'm going to talk about an impasse prevention technique that I've found really useful. One problem is the issue of principal LE or principal AL. So often people say, this is not an issue of principal LE, it's just about the money. And I've heard some mediators say, if they say it's just about the money, it's actually an issue of principal LE. And if they say, no, it's not about the money, this is an issue of principal LE, it's actually about the money. I don't necessarily agree with that. But I recognize that both kinds of principal are sometimes involved in cases. Now, you might say, if the parties are in an impasse, they've already come down from 6.5 million to $1 million. They've already come up from 250, down from 6.5 million, 2 million, up from 250,000 to $1 million. Now they say, no, we're not budging. It's an issue of principle. Well, what do you mean? You already compromised. Why is the step beyond $1 million or the step down from 2 million an issue of principle LE? And I think what people are articulating, I think we should honor this, I think it's a reasonable point, is that the question of fairness and reciprocity. What they're really standing up for is something that we humans are hardwired to do, which is to stick up for fairness. And if they feel that a number that is beyond their point of resistance is really unfair, they're going to sometimes wind up shooting themselves in the foot because there's a possible settlement here that would advance their interests. But they're sticking up for a fairness principle that is in our gut for all human beings, actually. And this can be demonstrated using the ultimatum game, which if you don't know what it is, just Google the term ultimatum game. There's some interesting social psychology research about how people will turn down free money if they feel like they're not being treated fairly. That's the LE principle. Extreme offers. Eric Green, who's a fabulous mediator, has done some really interesting discussion of this. And I think he actually talked about this in his Will Work for Food talk, which I listened to, and I thought it was fabulous. We often are in situations where people make very extreme demands or very extreme offers, and the response is an even more extreme response. And he calls this the spiral of doom. So part of our job as mediators in terms of breaking impasse is to prevent that kind of impasse by reasoning with people. But what as to, well, what do you think is the likely response to this offer? Do you think they might view it as extreme? And often, if they're seasoned lawyers in the room, they'll say, yeah, they might. I said, okay, well, then what would happen? Well, then they might make an extreme, response. And then what would happen? Well, we wouldn't bid against ourselves. We would just tell them they have to, they have to make another, provide another number. I would say, well, they're not going to want to bid against themselves. So we might get kind of stuck early on. So we can reason with people about what the expected, what might happen. And if they do make an extreme offer, we have all these tools in our toolbox. In the book, The Art of Impasse-Breaking, there are 60 tools for breaking impasse. So we have a lot of tools in our toolbox, but sometimes it leaves such a bad taste in people's mouths when an offer is very extreme that it really can kill the mediation. So we need to head that off. Now, I talked about techniques for impasse prevention, and I'll be very brief on this topic because it's a pretty large topic. I'm going to give you some links that you can use if you want to take a deeper dive. It's the internal family systems model, which I have found to be one of the most useful psychological models of what makes people tick. It was created by Dr. Richard Schwartz. He's written a number of books, but this one that's on the slide is written for a lay audience. It's the Introduction to Internal Family Systems. And it's a very inexpensive book. It's available widely online, and I highly recommend it. The IFS is an evidence-based method of psychotherapy, and you can see in this article one study showing its equal in effectiveness to cognitive behavioral therapy. But it's also useful for us mediators and lawyers and negotiators. The basic concept is we all have parts, and our parts inside each one of us are engaged in constant negotiation. One part of us is thinking we need to resolve this and move on. Another part of us is saying we're not going to be taken advantage of. The link on this slide will take you to an article called What Makes People Tick, and it's about IFS for mediators. And this link, if you're like videos more than articles, this is a video of a talk that I gave for the program on negotiation at Harvard Law School about how conflict resolvers can use this IFS model. If you want to take a really deep dive, I asked Natalie and Jean and David and Jeff if I could share this slide. This is a workshop that's happening this fall. The IFS Institute invited me to put together a workshop, a 6-week workshop. It's 18 hours, 3-hour sessions, once a week for 6 weeks, about using the internal family systems model for lawyers, mediators, and other conflict resolvers. Just click on Google IFS Institute and it'll take you there. So I said I wanted to leave time for Q&A, and the floor is open, and perhaps there are things in the chat. I haven't been looking at the chat, so I don't know. But I'm interested in your reactions, your disagreements, and anything that perhaps I haven't been clear about.
David, thank you so much. What a wonderful, comprehensive presentation. Just terrific. You've gotten many, many laudatory comments in the chat. We have over about 235 people here, which I think may be a record for us, actually. Since there are so many people, I'd ask that folks pose questions in the chat rather than speaking out loud. So if folks do have questions, please type them into the chat and we'll field them and uh, we'll get David's insights. Surely people must have questions.
And by the way, I invite disagreement. So, because mediation is more art than science, and I think it's really helpful in these Zoom gatherings to be learning from each other.
Well, David, I'll start with a question on mediators' proposals. That's always a popular topic. I find that in the crafting a mediator's proposal, oftentimes there's a little mini mediation going on between a lawyer and the lawyer's own client about where the case ought to be settling. And I will often ask lawyers, not only is it time for a mediator's proposal, but I'll actually talk to lawyers about what do you think the mediator's proposal ought to be? And sometimes the lawyer will say, what are you talking about? Why are you asking me? It's supposed to be your proposal, not mine. And I say, yes, but I care deeply about whether it's accepted because we all know that if it's not accepted, it causes us some challenges. So I'll often ask lawyers, I'd like to know if there's numbers out there that you would at least consider recommending to your client, even if grudgingly. And I find that if I can get a lawyer's buy-in on that extra step, and sometimes I'll have these conversations with lawyers separately, always away from in the cockpit, with the door closed. Sometimes with the lawyers together and sometimes separately. And I find that by doing that, I've never had a mediator's proposal fail to be accepted if I've gotten the lawyer's buy-in that they will recommend it, at least grudgingly, to their client. Do you ever take that step? What's your view?
Um, See, Jeff, this is a great example of how mediators do it differently, because I have done what you suggest, what you just described, and I have maybe less success doing that, or I have more trepidation doing it for the following reason. When I invite that kind of input, I find that sometimes the lawyers or the parties say, well, it's really your call, but I'm telling you right now, if your mediator's proposal is higher than $300,000, it's dead on arrival. Because that's the absolute farthest we're willing to go. And I've got a plaintiff who's at $500,000, and I don't think I can get them to $300,000. And what I'm concerned about is if I invite their input about what the proposal should be, they may interpret that as an invitation to tell me their bottom line. And I don't want to know their bottom line. I hardly ever ask them that until they got one foot on the elevator, because I find that they paint themselves into a corner and they feel like they'd be losing face if they then move off of that number. Sometimes they volunteer the bottom line without my asking, and that creates a problem. But I really appreciate your sharing the experience you've had, which is when you invite that kind of input, it works really well. So I may wind up putting your version of that tool in my toolbox and trying it out.
Well, I think, David, part of the reason that it generally works when I do it is it's generally not the first time I've called the lawyers apart from the clients and had a meeting with, in a simple plaintiff defendant case, had a conversation with the two lawyers because we have impasses all throughout the day, right? If we're going to have a set of brackets, okay, folks, what should the next set of brackets be? And trying to engender a sense of collaboration between the lawyers as the day goes on, I think it's something that I find really pays off big time, particularly at the end of the day when we're trying to get a mediator's proposal that both sides will accept and avoid all the complications and hairy messes we get when a mediator's proposal is not accepted.
So, Jeff, let me just respond to that. And I noticed in the chat a question that I want to address about Zoom mediation. But on the subject of mediator's proposal, anybody who Googles the phrase mediator's proposal might see an article about how mediators shouldn't use or don't use mediators' proposals anymore because the lawyers and the repeat player parties know that we're going to do that, or that we might do that. And so they strategically try to obfuscate what their real reserve price, their bottom line is, so that they can influence the mediator's proposal. They try to spin the mediator, in other words. And I respect that point of view. I have not found that to be the case, but maybe I'm naive. Maybe they're spinning me in ways that I'm not aware of. But suffice it to say that in our field, there's controversy about the use of the mediator's proposal, and yet it seems to be very widely used. If I can shift the topic for a moment to Zoom, I saw in the chat a question about that. And I guess I have two thoughts about it. Number one, I can't, if I'm doing a Zoom mediation, I show the parties on video my dog Bella, because even through Zoom, when they see a golden retriever, it warms their hearts. But Bella does much better work in person than via Zoom. And I find that my peripheral vision, my ability to see the reactions of the parties, is of course much greater when you're in a room with people. However, there are certain kinds of cases that I think benefit from Zoom, particularly when there are power imbalances and where one party might feel a little intimidated being in the physical presence of the other party. So I think we mediators have to be thoughtful about what is the best modality for this particular case. And I think many of us have experienced during the pandemic, we are now getting mediation cases where parties are in opposite ends of the country, different parts of the world, cases we never had before because it was too expensive to fly everybody in. Zoom creates a great opportunity. And I don't think it has reduced the impasse breaking function as far as I can tell. Jeff or David or Jean or Natalie, if you've spotted questions in the chat that you want to put forward, please do.
Well, it's just 1 minute before the hour, David, and I think if we pose any more questions, you probably will not have a fair opportunity to give your usual thoughtful answer to it. So I think this is the time when we should say thank you. And I think this is the time when we should remind people that if they are so moved and if they're able to make a contribution to the Greater Boston Food Bank in your honor, that would be fabulous. And we invite people to let us know about the contributions they've made so that we can add it to our running total. We had, I think, 238 people here at the peak number. I think that may be the greatest number of people we've ever had, David, and that's a testament to your reputation and your skills and your devotion to the field and to your good heart. I want to tell you that we really appreciate your being here. Thank you so much. And with that, we are complete.
So long, everybody. Thank you for being here. Thank you for supporting Greater Boston Food Bank.
Thank you.